Alright, I have my motion to strike surplusage ready to go, which I've already submitted to the prosecutor, and I'd like to share it with everybody here. So if we could get started, I just want to make sure things are running okay. Alright. Defendant's motion to strike surplusage. It is 9 pages. Commonwealth of Kentucky versus Travis Heinze. Come now, the defendant pro se respectfully moves this court to grant defendant's motion to strike surplusage from the Commonwealth's Uniform Citation, charging defendant with violation statute 511.080, trespassing 3rd degree. In support of the motion, the defendant states as follows. Introduction. The charging document, titled a Uniform Citation, describes that on January 3rd, 2024, starting at 1:49 a.m., the defendant was contacted by McCracken County Sheriff's Deputy in the parking lot of the Southland Baptist Church, located at 927 Yarbro Lane, Paducah, Kentucky, while he was parked in his personal vehicle. Defendant was arrested, transported, and lodged in the McCracken County Regional Jail. The Commonwealth first delivered the charging document to defendant on January 11th, 2024, soon after defendant first appeared in court. By the Commonwealth citation, defendant is charged with a single count of violation of Kentucky Revision Statute 511.080, criminal trespass in the 3rd degree. At issue is the court should order the Commonwealth to strike the surplusage of prejudicial and unnecessary allegations as permitted. Defendant brings this motion pursuant to Kentucky Court Rules 6.14. And that Rule 6.12 says an indictment, information, complaint, or citation shall not be deemed invalid, nor shall the trial, judgment, or other proceedings thereon be stayed, arrested, or in any other affected by reason of a defect or imperfection that does not tend to prejudice the substantial rights of the defendant on the merits. Alright, and then the Rule 6.14 surplusage. Unnecessary allegations may be disregarded as surplusage, and on motion of the defendant may be stricken from the indictment, information, complaint, or citation. And that's my power. I get to make a motion for that strike. Let's see. Rule 6.12 permits a Rule 6.14 motion to eliminate defects or imperfections that tend to prejudice the substantial rights of the defendant on the merits. Facts and allegations are prejudicial. If they could lead a jury to base its decision on emotional grounds, they could be used for an improper purpose, and or the potential for prejudice outweighs the probative value. Alright. This court has consistently held that evidence is prejudicial if it could lead the jury to base its decision on emotional grounds. Clark v. Commonwealth. Or if there is a risk that the evidence would be used for an improper purpose. Purcell v. Commonwealth. Also, the probative value must not be substantially outweighed by the potential for prejudice. Additionally, allegations of non-criminal blame are prejudicial to defendants when they are merely conclusory, alleging blame without factual support from which defendant may mount a defense. Defendant contends that the bulk of the charging document assigns blame to defendant for circumstances in conduct that are neither criminal nor blameworthy. The bulk of the charging document does not support the charged crime of criminal trespass 3rd degree. The sentences and phrases identified herein as surplusage have the prejudicial effect of casting defendant as a person who is wrong and blameworthy while containing no probative value. Proceeding sequentially through the narrative in the citation, defendant identifies prejudicial surplusage. The paragraph numbering is restarted here at 1 with paragraph numbers matching those in the attached proposed order, enabling the court to rule on each individual request to strike surplusage. On January 3rd at approximately 12:39, Deputy Weldon made contact with a suspicious vehicle parked in the lot of Southland Baptist Temple. The word suspicious is surplusage, stating blame against defendant for something that is immaterial to the crime charged. The complaint contains no further explanation establishing suspicion as material to a trespassing violation, to the extent that the word suspicious is intended to bolster reasonable suspicion, justifying the initial contact. Its current context fails in making the link. The unsupported suspicious descriptor offers no probative value, yet prejudices defendant first by assigning blame for a non-criminal conduct, and second by offering no detailed allegation of suspicious from which a defense may be initiated. For these reasons, the word suspicious is prejudicial surplusage that should be stricken. Southland Baptist Temple has previously requested assistance from the sheriff's office with preventing people from loitering on their property out of concern for the thefts and drug activity prevalent in the area. Absent a written agreement with Southland Baptist Temple, Deputy Weldon had no authority to enforce any suspected trespassing violation on private property. The citation does not state observation of any other crime that justified either a traffic stop or Terry stop. This includes loitering, theft, and drug activity. As a matter of law, loitering involves one of four activities of A. Gambling in a public place. Gambling in a public place. Drug activity in a public place. Remaining without legitimate reason at a school, or D. Soliciting merchandising at a transportation facility. The citation is devoid of facts attaching defendant to suspicion of any of these activities. Defendant has not been suspected or associated with loitering, theft, or drug activity. Mention of such crimes prejudices the defendant by offering his association with deplorable conduct, while offering no factual details from which defendant may mount a defense. To the extent that the Commonwealth contends that a similarity between previous activity at the church and defendant's conduct justified their contact with defendant, such connection has not been stated in the charging document. Without such connection as an essential fact, and there is none provided, this sentence is prejudicial surplusage and should be stricken. Upon observing the vehicle, Deputy Weldon was unable to read the registration plate due to it being partially obscured by a strap used to secure bicycles in the rear of the vehicle, as well as bicycles themselves. The registration was finally given to dispatch correctly and was confirmed to be valid. These sentences assign blame to defendant. It is clear that Deputy Weldon is not blaming himself for calling in the license plate incorrectly. There is no other alternative than an interpretation that defendant is being blamed for the straps and bicycle that partially obscure the plates. As this accusation is unrelated to the charged crime, this assertion of fault is prejudicial to defendant. Thus, the sentences are prejudicial surplusage, and the sentences should be stricken. To strike completely, the operator of the vehicle was asked repeatedly for his identification, which he refused to produce. Deputy Weldon did not and cannot state any authority requiring that defendant produce identification. This was not a traffic stop. No traffic stop was authorized. Defendant was not operating the vehicle. Supposing that this was a Terry stop, the Kentucky Supreme Court has clearly established there is no authority for a Kentucky peace officer to demand identification under threat of arrest during a Terry stop. Whether a Terry detainee is required to provide identification in an effort is determined by state law. Let's see, Hibble v. 6 Judicial District Courts of Nevada. State law requiring a suspect to disclose his name in the course of a valid Terry stop is consistent with Fourth Amendment prohibitions. In support, the Hibble court cited 20 other states with so-called stop and identify laws. Kentucky cited 20 other states with so-called stop and identify laws. Kentucky is not listed as one of those states. The Hibble court further held that in states without such laws, a suspect may decline to identify himself without penalty. After reviewing pertinent federal and Kentucky law, we conclude that the Commonwealth of Kentucky is not a stop and identify jurisdiction. Therefore, absent a statute requiring disclosure, Kavanaugh could not have been arrested and prosecuted for failure to provide identification. However, since an officer is constitutionally permitted to request identification, any failure to comply may still be considered along with other sufficient factors demonstrating reasonable suspicion. If Deputy Weldon had reasonable suspicion to initially detain defendant a point that defendant does not concede, then yes, Kavanaugh established that a failure to comply may have justified further detention, but only for the purpose of further investigation of the same factors justifying the detention in the first place. However, Kavanaugh establishes that any failure to comply with a request for identification is not criminal. Deputy Weldon's assignment of blame in that defendant refused to produce is further amplified by asked repeatedly, which only amplifies an immaterial conduct that is neither criminal nor related to the charged crime. For these reasons, the phrase is prejudicial surplusage that should be stricken. Being more concerned with ensuring that his many cameras were operational and turned on to record the interaction from multiple angles, presumably to post on YouTube, as he had multiple YouTube reference decals all over his vehicle. Deputy Weldon assigns blame to defendant being more concerned with his First Amendment protected right to record and publish his interaction with the police than he was with addressing a non-compulsory task of answering a request for identification. There is no blame to be placed for defendant's rational conduct. The assignment of such blame is prejudicial to defendant and offers no essential fact to support the charged crime of trespassing. The passage is prejudicial surplusage and should be stricken. Deputy Kane arrived to attempt to assist with the situation and was also unable to garner cooperation from the operator. Deputy Weldon attempts to magnify blame for otherwise blameless conduct by stating that the blameless conduct was encountered by a second peace officer. The only element of cooperation being sought by Deputy Weldon and Deputy Kane was identification. No unlawful lack of cooperation is detailed in the citation. Most notably, at no time did any officer take any investigative steps towards determining that defendant had mens rea, that his entry onto the premises was unlawful. In short, the citation offers no essential facts demonstrating that defendant committed the charged crime. As this sentence assigns blame to defendant for blameless conduct observed by a second peace officer, the statement prejudices defendant and should be stricken as surplusage. Sergeant Burrow arrived and again advised the operator of the vehicle that he was trespassing on private property. The sergeant's advisal to defendant that he was trespassing does not in any way describe essential conduct of defendant in violation of the charged statute. A defendant may not be charged with a crime by the simple statement the officer told defendant he was committing a crime. The citation does not connect the sergeant's advisal with any conduct upon which defendant can argue his defense, either by fact or by law. Nevertheless, the accusation was made, and this statement is not challenged by this motion. Oh, it's not challenged. Okay. He advised the operator that our intent was to identify him. The sergeant's advisal of intent to identify is indistinguishable from previous requests for identification as discussed above, and for that reason should be stricken as prejudicial surplusage. Confirm valid insurance for the vehicle, as we were asking him to leave in that vehicle from the church property and to allow him to leave. The sergeant had no authority to demand proof of insurance. The citation states no authority for demanding proof of insurance. This was not a traffic stop. Any request for proof of insurance is not an essential fact related to the charged crime of trespassing. The sergeant was stating only a conditional allowance of departure by defendants, and the conditional act was not required by law. As such, the sergeant was not allowing defendant to leave the church parking lots. Furthermore, the sergeant was insisting that defendant leave the church parking lot in his car. The statement that the sergeant would allow defendant to leave, but only in his car, and only meeting the unlawful demand for identification and proof of insurance does not provide any essential fact that support the charged crime of trespassing. The sergeant was offering an unlawful quid pro quo: provide us information unrelated to trespassing or we'll arrest you for trespassing. There is no logical connection between defendant's decision to decline constructively by inaction the improper proposal and any essential facts alleging that defendant either knowingly entered unlawfully or knowingly remained unlawfully on any premises. Kentucky Revised Statutes 511.090 isolates and defines the phrase enters or remains unlawfully, such that the knowingly of Kentucky Revised Statute 511.080 applies to unlawfully, thus indicating the element of mens rea consistent with the body of Kentucky common law stressing no trespassing signage and or an authorized notice that the offender's presence is unwelcome. The statement at hand only serves to blame defendant for failure to provide a second document that he was not required to provide. As such, the statement is prejudicial surplusage. All right. As I said, prejudicial surplusage. The operator continued to be more concerned with arguing and getting recordings of the interaction than he was with the repeated lawful requests for identification and vehicle insurance. This statement repeats the assignment of blame for the First Amendment protected activity of getting recordings that has already been addressed. The categorization of requests as repeated lawful requests is immaterial. Defendant had no obligation to answer the request. No law required defendant to provide identification or proof of insurance. No law authorized the officers to restrict defendant's departure as allowable only upon meeting their demands. The statement assigns blame for arguing which is neither a crime nor factually related to the charged crime of trespassing. Defendant's alleged conduct in arguing against police demands was perfectly rational and is neither blameworthy nor criminal. The freedom of individuals verbally to oppose or to challenge police action without thereby risking arrest is one of the principal characteristics by which we distinguish free nation from a police state. The statement conflates lawful requests with lawful demands and encourages an erroneous conclusion that defendant's conduct was unlawful. For these reasons, the statement's assignment of blame to defendant is prejudicial, while providing no support for the charged crime. Thus, the statement should be stricken as surplusage. Requesting redaction to the operator was placed under arrest. After a final warning that if he failed to produce identification, that he would be arrested for trespassing in lieu of being allowed to drive away immediately upon confirmation of his having a valid operator's license and insurance. The operator was placed under arrest when he continued to argue rather than comply with the lawful request. Beyond the fact of arrest, there is nothing new in this sentence that has not been addressed. Identification, conditional permission to drive away, proof of insurance, arguing, and a categorization of lawful requests. Having previously addressed each issue in turn, this sentence is established as prejudicial surplusage that should be stricken with the exception of the factual statement. The operator was placed under arrest. Requesting a redaction to the operator was identified as Travis Heinze. Search of this person incident to arrest for criminal trespass. Third, revealed a wallet containing his Washington State identification and the identity of Travis Heinze. The fact that a search revealed a wallet only serves to again accuse defendants of failing to provide his driver's license, which was failing to produce. I seem to have lost my spot here. Let's see. Let's see. Stranger in town. Just kind of skip it, I guess. These identified allegations are not essential facts supporting the charged crime, and they all have a tendency to assign blame or cause prejudice for lawfully ignoring a demand for identification. Defendant requests that the sentence be redacted and surplusage to read the operator was identified as Travis Heinze. His vehicle was left parked, modified to read his vehicle was left parked on the lot of Southland Baptist Church. He continued to refuse to produce insurance for the vehicle. This issue of proof of insurance has been previously addressed and should be stricken as prejudicial surplusage, which was left parked on the lot of Southland Baptist Temple with his cameras attached. The issue of cameras has been addressed as First Amendment protected activity. Additionally, the handling of defendant's car offers no essential fact connected to the charged crime. Despite these arguments, this phrase blends well with video and audio recorded derisive, disrespectful comments by the three officers as they expressed sadistic pleasure in knowing that defendant will be forced to walk over 4 miles from the jail back to his car at 3 a.m. with the temperatures around 24 degrees. For these reasons, defendant requests that the mention of cameras be stricken, blending 13 and 14 to read, his vehicle was left parked on the lots of Southland Baptist Temple. To strike completely, broken windshield and passenger compartment full of miscellaneous items piled so high as to potentially prevent him from safely operating the vehicle without moving them from his field of view. This description of defendant's vehicle offers no support for the charged crime. This was not a traffic stop. These three police officers earlier advised defendant to produce identification and proof of insurance and drive away in the same car they now describe by assigning blame to defendant. Such assignment of blame for the condition of his car is not an essential fact and is prejudicial to defendant. The statement should be stricken as surplusage. Not challenged, Heinze was transported and lodged in the McCracken County Regional Jail. Conclusion. All right, whereas in the foregoing reasons, the defendant respectfully requests that this court grant this motion to strike surplusage. And then there's just check marks for the judge after that.